Welcome, folks. This is, I'm going to check the date here. This is Tuesday, July 12th. This is Joint Justice Oversight Committee. We are doing our second meeting of our off-session meetings, and we do have a full agenda. The agenda is posted on our committee webpage, and we do have paper copies here. And we do have a full agenda this morning. And I'm going to give the Commissioner of Corrections time to catch his breath. And Dale Crook from DOC is with us on Zoom. So the first item that we have up today is update on the probation midpoint review. That's required by statute. And we did make some changes to the midpoint review process during this past session. And then we'll move on to another requirement for us to look into S3, which deals with competency to stand trial and the insanity as a defense. We'll be looking at that particular section. So we do have a full morning and we do have a full afternoon for that. So questions? Okay, Commissioner, are you ready to start, or should we start with Dale Crook?
I'm happy to start, but Dale is going to be your expert on these matters. Where would you like me to sit? Down here. Okay.
It's a little different.
Happy to do it. Yeah, I know you moved it around.
Yeah. This is set up as a committee room for his House committee. So Commissioner, I'm going to turn it over to you just to give us an update on how the midpoint review process is working. And it would be good to know how many cases. There was quite a bit of a backlog.
Yeah.
In cases back in January and February. And as the session progressed, the court started working through that. So we need an update on how it first rolled out, but also where we are at this point.
Great. Well, thank you very much for having me here. I'm Nick Demmel, the Commissioner of the Department of Corrections. Nice to see you all over the summer. So on the more substantive topics here, I think Dale is probably best positioned to give you the facts that you're looking for, and happy to discuss the policy and some of the work we've been doing over the last few months. But I'll turn it over to Dale Crook, our Field Services Director.
Thank you, sir. Dale Crook, Director of Field Services, Vermont Department of Corrections. So the midpoint review went effective on passage. We were able to get our policies and training of our staff updated. Policies were assigned by the Commissioner end of May 31st. All indications, I spoke with my managers this week, and no issues. It's in effect. We are submitting reviews to the courts. I have not heard any feedback or any concerns from our criminal justice partners, the state's attorneys or the courts. So far, that seems to be moving. That would probably be of interest to talk with them at some point. They're very much an interested party. In August, we will be presenting a report on August 1st regarding the data, the number we had. I do know during testimony we talked with the previous version of midpoint review, the number of 800 midpoint reviews were filed shortly after it went into effect. And then we had challenges, legal challenges, and determined that a lot of them were not retroactive. At this point, we have not heard of any of those same situations or concerns this time around with the new language. We're in the process of data cleanup so that when we do pull those numbers in a couple of weeks, that we'll be able to give you a clear indication of what the outcomes and what it's looking at as far as discharge. I can tell you that our probation numbers as a whole in the last 5 or 6 months has increased a little bit, but that should not be surprising as the courts have been starting to send more and more cases, but our overall population in the field has remained the same for the last couple of months. So I think at this point, it may be a little premature But as far as the department is concerned and the staff, midpoint term probation midpoint reviews are in effect. It is retroactive. So staff have gone and looked back at cases that were at their midpoint or beyond and have submitted reviews that they met the criteria that was laid out in statute. I'd be more than happy to answer any questions.
So Dale, not everyone sitting around the table here worked on this. There's a few of us. So it might be a good idea just to give a brief review in terms of when does the midpoint review occur within someone's probation, and what the process is. And also last year, well, when we began the session in January, there was a logjam of the reviews in Washington County Court. And the legislation that we put in place this past session allows those cases to be looked at courts around the state. So it wasn't just limited to Washington County. And we need to hear how that's working as well.
Excuse me, Madam Chair, I believe that you were talking about the Rule 74 with the furlough violations. That was where the logjam occurred in Washington County.
Right.
You had us do a lot last year, ma'am. So we're trying to. Sometimes I can't keep things in place. So I can do a quick history lesson with term probation midpoint review. Originally, it was passed many years ago, and through Justice Reinvestment, they thought that there could be some more certainty applied to it with discharges that were on midpoint review. That was one of the recommendations that came out of councils of state government. So there was discussions with the legislature, and a version of midpoint review was created. And what the midpoint review is for individuals on probation that have a set term of probation, that the month prior to their midpoint of their term, that they would be eligible for a review. And during that review, there's some certain criteria that the probation officer would go through. And if the supervised individual met all the criteria, we would submit a review to the court to have them review the case. The department's review is we do not have a lot of discretion. It is very much, kind of checking the boxes. Are they pending charges? Have they been found in violation previously? Things of that nature. So for the review part for the department, it's fairly straightforward. The real onus on this kind of does fall on the state's attorney's office, where they have it is their responsibility to object if they feel that the motion for review creates a public safety issue or concern, and then the judge will make a determination on that. If the state's attorneys does not oppose or object or gets back to the motion for review, it is granted by the court. So there is time frames imposed on the state's attorneys on when they need to respond back to our motion for review. So with that passed in 2020, there was some concerns. There was a legal challenge that it was not retroactive. And I believe there's language that has to be in updating statutory language that has to indicate that it is a retroactive component to the midpoint review. At that challenge from the court, it was determined that the court that only cases that were sentenced after the effective date, which was July 1st, I believe, July 1st of 2021, would only be eligible for review. So that really did, take out thousands of cases of probationers that we had on. That was not the intent of the legislation. The legislation kind of updated it a little bit and changed and made sure that it was retroactive, and that went into effect upon passage. And now we are currently following the new language. So right now it does appear to be working. We have not had any legal challenges. Really, this is, I would assume, local sites and local state's attorneys will be applying their review of it as they see fit. Some may be challenging, some may not be, but right now cases are getting reviewed and cases are getting discharged under the midpoint review. Regardless of the midpoint review, the department still has the authority to recommend discharges with justification for other cases as well that don't fit the midpoint language as well.
Questions?
Dale, can I just ask a clarifying question? In the beginning of your statement, you were talking about some 800 or so cases.
Yep.
So that was last year?
That was shortly after when it went into effect on July 1st. I think what happened is we were trained and ready to go, the Department of Corrections and this probation staff, and we started filing discharges that met the criteria that we thought it met the criteria. So it was everyone that was at the midpoint or before. So we filed 800 cases. And I think probably, and our estimate is it kind of shocked the system a little bit. So not all of them were heard. It was kind of a new process. And I think there was some confusion with the new process and the greater system of the criminal justice system. There were some legal challenges that were done. State's attorneys did file some objections and legal challenges. It ended up going before a court, I believe down in Windham or Windsor County, and it was determined that it was not retroactive. So a lot of those cases that we filed for were null because they were passed. We applied the retroactivity to them. Some of those cases we actually still recommended a discharge outside of the midpoint review and got them discharged anyway. The department really did take its responsibility in the direction that justice reinvestment kind of thrust it upon us to continue with. We took that seriously. So if cases we thought were appropriate for discharge, we still moved forward with discharging those individuals.
And so how many people were ultimately discharged from probation?
We don't have. I don't have that number on me. We're going to be pulling data for the report for August 1st is when the report is coming to the legislature. It's really kind of difficult because we're taking two different processes that had a court decision in the middle of it. So we're going to be applying it to really a shorter time, but we would expect to see a lot of cases that have been filed. So as far as what the outcomes will be, we won't really be able to tell until we pull all the data, and that will be in a couple of weeks.
Okay. And will you be working with the state's attorney's office as well in terms of, I see that they have responsibility for notifying victims or attempting to notify victims. Will that data be included in terms of the number of people they are able to notify as a result of that?
That will not come from the department. We would not track state's attorneys' victims' contacts. I think we would be able to indicate how many cases we filed, how many cases we didn't file, and kind of what the outcome of those discharges were.
Okay.
Butch?
Thanks. So, Dale, so I think I'm hearing that you really don't have a way to track victim interaction in the process. I was a victim and I was not happy that the person that had committed the crime against me had been sentenced probation, and I'm not happy with that. How do you track that if they get involved with the discussion?
So the statute has the state's attorney's victim's advocate that's responsible for the conversations with notifying the victim, and then taking the victim's concerned to the state's attorney to see if they choose to object or not. We do have contact with victims, and we do have discretion with our victims advocates, and there will be cases that they will reach out and touch base with, and to make sure that they're good, that there's safety concerns. So our victim advocates do touch base with with our population. But as far as this and the midpoint review is concerned, it's the state's attorney's responsibility, and we wouldn't track their interactions with their victims advocates.
Okay, thanks. And I'm a little puzzled that we don't track that. Maybe the state's attorneys do as a group, but.
Maybe they do. I would not know what the state's attorneys track as far as their information.
Thank you.
Yep.
So I know, Dale, that you mentioned August 1st, when you submit the report, you'll have more data in terms of the number of folks and how many have been discharged. So
Yeah. Yes, ma'am. And I do think that's going to be a relatively short capture period with the new midpoint and really capturing it good. I do believe there's another one that we will do in 2023, which will probably give the legislators and give everyone a full picture of what it's like. Because as cases are getting resolved now and put on probation, there's the understanding that there is this midpoint review and sentencing will be kind of adjusted to take that into account at the local by the local state's attorneys and the courts. So I think, after a good year of collecting this data, I think we'd be able to see a good capture of what the midpoint review is going to do. I would say, looking at it right now, I think it is going to be relatively successful at the minimum, that we are moving cases that don't need to be lingering on probation longer than they have to be. So I would foresee that it would be a positive outcome with our data, that if the intent was to limit the timeframes of individuals on probation that do not need to be on probation, I would expect that this would meet its goal.
And do you think that there'll be a lot of folks who are denied discharge from probation at the initial review, midpoint review, due to some circumstances that will then come back in a few months later or a year later?
That's all possible. I mean, it really depends on what the objections were, what the concerns that the state's attorneys brought up, what the decision of the courts made. Is there an opportunity to have it reviewed later down the road? But the midpoint is really at the midpoint or any point thereafter that they become eligible. So if the courts say no, and they say they need to do X, Y, and Z, at that time X, Y, and Z is done, they could still be eligible for review again. So it's really we don't want to hold the cases that don't need to be on with us, right? So the cases that we want to put our energy and efforts into, which is kind of what the purpose of the direction that CSG and JRI gave us, was really the ones that are violating and causing issues. That's where we put our energies and efforts into, and the ones that are doing okay and not creating disturbances and issues that probably doesn't need our attention, those are the ones that we would have discharged from probation.
Well, this is a little bit off the subject of just midpoint review, but it's becoming increasingly clear to me that there's a lot of concern about the amount of violence in our communities, and some of obviously can be seen through firearm use and et cetera. And one of my concerns is that we lose sight of all the work we did in investment too, and not keep good track of the results. So you're going to have some positive results, but at the same time, you're going to have pushback on many of the reports. So I'm wondering if there's a way to work with legislative counsel on keeping an inventory of the things we did as part of justice reinvestment and its impact on the population and impact on the crime rate. I am very concerned about the pendulum swinging back once again as a response to what's perceived. And I haven't seen the statistics yet. I mean, I know my local police department met with its select board about the increase in crime Monday. And yet there aren't statistics on it. We do read in the press about increased number of shootings and so forth. But, so is there a way of working with our lead counsel and keeping track of what we did in justice reinvestment too? The midpoint review being one of the major pieces. The and there were many others. And kind of melding that into some kind of a updated report. That gives us a little more information than just the numbers who are incarcerated.
I think that's a good, I think what's happening out in the public is the feeling that people are getting away with things and there isn't the response that the public would like. And we have been putting in initiatives, but folks like the midpoint review and probation, they already have a sentence. Their sentence is probation. So they did have some consequences to their behavior. We also did the furlough interrupt. Again, they have a sentence, they've served some time in an incarcerated setting. Furlough is a program of helping folks reenter into the community, but still be under the supervision of the Department of Corrections. So maybe in response to Senator Seo's question, there isn't an answer at this point between Ledge Council and DOC. It might be something worth vetting. It might be something as a, one of the directions of this check-in on the midpoint review is also to see if there's future or further legislative action that's needed. That may be an avenue.
Well, yeah, it also, we looked at diversion and the number and all of that material last week on how to one diversion system, which is also another part of the reform. But you're absolutely right. I think one of the concerns I hear is catch and release. That's the general term of, we catch you and then we release you and you go out and commit a new crime. But we don't have any statistics to back that up. It's all anecdotal. And it's concerning to me.
So,
The perception becomes reality.
yes.
And that's what we're struggling with, because I think the person on the street does not know the layers in terms of the process. When someone is arrested, it doesn't automatically mean that they're going to be in jail. There's a court process, and the court makes a lot of these decisions, and DOC is the holding tank. I mean, DOC isn't the one that makes the ultimate you're incarcerated, it's the courts.
So it doesn't mean they're guilty either.
Right.
So, I think the idea of working with legislative council and finding a way to package that for you all is an important one. I wanted to highlight, though, last week we announced as part of a different initiative, but we included it in there because it was important to that initiative, that the department is restructuring its own data analysis team. So the team that focuses on our data research analysis, historically, that team has been quite small and it's been pretty focused in on certain topics. But what we'd like to do is expand that team out to focus on some of the things that I think you're talking about, Senator. And so we announced it last week as part of a staff issue, and it is something that we also don't have great data on our staff, and it's hard for us to make really informed kind of evidence-based decisions about where to go with staff or compensation, things of those ilk without that data. The same is true, though, of our mission. And that's where I think of the JRI work and much of the work that Dale's team does and we do in our facilities. How do we collect good data on that? How do we create measures so that we can see, are we being effective? Are we not being effective? And look, and particularly, I think this becomes valuable when you can do that over time and you can really see, well, that was a great initiative. This over here just didn't work. And so why didn't that work? The first place to do that, though, is creating a team that can do that level of analysis and provide that kind of consultative support to Dale, to our leadership, but then also to inform the legislature and help guide you all in, hey, there's a gap here in the legislation, or some assistance on this front would help us. So that team we want them to focus on kind of 4 key areas. The one is our people, our staff, and to help us with our recruitment and retention efforts. The next is the mission, which is, I think, exactly what you're asking of us is, can you give us better data to say, this is working, this isn't working, or just objective truths that we can look to. Also our infrastructure, so the physical structure of the system across the state, which is a huge concern for us. And, we're looking to build a new women's facility. All of that needs to be underpinned by reliable, objective data. And then the fourth is our money. How do we spend money? Where are there inefficiencies? Where are there efficiencies? Is our money being spent against priorities? And to help us work through those analyses. So I think that effort could help to inform some of the mission work that you're asking us about. And certainly I think we can work with legislative counsel with that team to create reports that are might be more valuable to you all, or to propose ideas for legislation that we think will help advance the JRI objectives and continue that kind of nation leading work that we're doing there. That was a long answer to a question that didn't have a lot to do with the data team, but I do think that will be the vehicle where we can really make an impact for you.
It's a work in progress.
It's in process. I mean, the team exists. It wasn't resourced properly, in my opinion. And so we are adding some positions to it and reorienting them a bit to focus on this type of work, really to inform leadership decision-making and get us objective facts about our organization.
Teresa?
I appreciate that. And I think all of us have seen in our various committees the lack of resources devoted to data and delivering facts. But I guess isn't necessarily a question for you, Commissioner, but one of the things that I guess I would want to make sure that we do is that in order to complete that picture, it seems as though we need the state's attorney's data as well. Some of the questions that Representative Shaw was asking and looking at, it would just be incomplete if we only had DOC information, right. I think, so I think we need to make sure that, if we have some sort of even report at our September meeting, make sure to invite the state's attorneys, and that if we're looking to the future in terms of the reporting that Senator Sears was talking about, that we make sure we include all the entities that have a piece of that pie.
Butch?
Thanks. And to follow up on Representative Woods and Senator Sears brought out the catch and release phrase early on in the discussion. And I think I would tend to think that if we're asking you to track that data for stuff that people you've never seen, we're asking the wrong people. And so I agree with Teresa that we probably want to talk to the SAs. But as late as this morning, there was an interesting or damning editorial from the mayor of the city of Rutland concerning some incidents that have happened in their city, similar to what's happened in Bennington. The same person was caught for the same crime 3 times in less than a week, and right back out. And people are becoming to get fairly concerned about that. So do we take action? I don't know. If we take action, is it the right action? It should be.
Well, that's what concerns me, is we take the wrong action and undo some of the things that are working in order to close the path of some things that are perceived to be not working.
Sure.
And I'm always concerned when we do that. There is, as a citizen, I question sometimes, why did they let this guy go? Why didn't they put him in jail? Why didn't they keep him in jail? There may be details that we're unaware of. They may also, there could be hundreds of things. So I think it's important that we at least have the statistics, and I think you're correct that we need it from state attorneys, we need it from diversion, we need it from all players in the criminal justice system.
So if I can.
But that's the issue that's going to happen to us.
If I can just interrupt and put us on stop right now, and I want you to reiterate what you just said in a minute. I just got to note that when our YouTube was launched, it was launched under joint rules. and not Joint Justice Oversight.
Oh,
So this YouTube needs to stop and we need to relaunch in Justice Oversight. So I think this conversation is important for the public to hear. And I would ask Senator Sears to sort of repeat what you have just said.
Can we pass a few rules before we?
I'm gonna do that right now, okay?
Okay, so we're on hold. Peggy's gonna